Creative Legals, the show that helps you understand the law around property investment, whether you are a vanilla landlord or doing creative deals. Because what you do not know could cost you. Creative Legals, law for creative deals. Joining us now, your host, Julie Condliffe, the legal diva, successful property investor, and specialist property litigation solicitor.
Hey, thank you so very much for joining me again today on the Creative Legals Landlords platform, a platform where we love landlords, we're lawyers, we're landlords, and we do everything that we can to make sure that landlords are kept up to date on all things legal. So today I am so excited because I get to talk about the long-awaited Court of Appeal decision on gas safety certification, which was finally handed down just a few days ago. This case provides a fantastic outcome for landlords, so I'm really excited about it. The position commonly held was as per the Caridon case. That position was a failure to provide an incoming tenant with a gas safety record before occupation commenced would forevermore render the landlord in breach of a prescribed requirement, and therefore the landlord would be unable to forever serve a Section 21 notice. That was the Caridon case. In fact, most judges held that same view. So as a landlord, as a lawyer, you would almost know that if you're going to court on similar facts to that Caridon case, the chances of success would be very limited. Of course, there are always counters. In law, there's always, purposive interpretation, different kinds of interpretation. There are always other cases that will counter a particular provision. But the Caridon case was considered to be one of the leading cases in that particular area. So the question before the Court of Appeal was whether a landlord's failure to provide a gas safety record prior to a tenant commencing occupation of the property meant that a landlord would never be allowed to serve a Section 21 notice ever again on that tenancy. Put simply, this would mean a tenancy that was created just as an assured short-hold tenancy would automatically become a full-blown assured short-hold tenancy, where the only means of eviction for a landlord would be on fault grounds as per the Housing Act 1988. Now, this was quite a draconian measure in the sense that if you're a landlord who gave out an assured short-hold tenancy, say for 6 months or even a year, with a view to selling the property on, and then all of a sudden you find yourself in this unenviable set of circumstances where, because a gas safety certificate was not provided, either through no fault of your own or indeed perhaps an omission on your part, you find that you've now got effectively a tenant for life. You've got an assured tenancy, which you had no intention to create, no intention of creating that kind of tenancy. But just because the gas safety certification wasn't provided before the tenant occupied the property, you are now in this situation which you can hardly get out of. So can you see how crucial that was? The position is different now, thankfully, to this case. This Rouncefield case helps to establish that failure to provide gas safety certification prior to the tenant going in is not fatal to a Section 21 claim. So yay, good news for landlords. Now let's get a really good understanding of this case. And for us to be able to do that, perhaps we should visit the backdrop, just the history of the case. So this case is based on a property in beautiful St. Ives in Cornwall. It's one of a number of self-contained flats in a block of flats owned by the claimant. This particular flat is flat number 2. The defendant, Mrs. Rouncefield, became a tenant of this property pursuant to an assured short-hold tenancy commencing and dated the 20th of February 2017. That initial tenancy was for a period of 6 months. Now, The point worth noting here is that the landlord did not give Mrs. Rouncefield a gas safety certificate before she entered into occupation of the property. Instead, the certificate was provided to Mrs. Rouncefield in November 2017. The certificate that was provided to her in November 2017 was in fact dated January 2017. So that would imply that there was a gas safety prior to the period where she occupied the property. Now, over a year later, the landlord served a notice in May 2018 under the Section 21 Housing Act of 1988 provisions. Mrs. Rouncefield defended the possession claim on the basis that because no gas safety certificate had been provided to her prior to her taking occupation, the Section 21 notice should therefore be invalid. Her argument was that the landlord was not entitled to serve a Section 21 notice. She sought to rely on regulations 36.6b and 36.6.7 of the Gas Safety Regulations 1988. Now, those regulations are very important, and all the regulations in relation to gas safety are crucially important. I mean, regulations are important generally anyway, but the focal point of our discussion now is gas safety. So it will be right for me to mention that as landlords, we must ensure that we comply, because the consequences of non-compliance could really be onerous. For example, if a tenant were to die at one of your properties and as a direct result of your non-compliance with the gas safety regulations, you could actually be charged for manslaughter. You could also be charged for quite a few other criminal offences. So you've got civil, you've also got criminal. So I just thought as a side note, it would be very, very important for me to highlight that to you. So back to what we're talking about right now. Mrs. Rouncefield was seeking to rely on the 36.6b and 36.6.7 provisions of the gas safety regulatory instrument. Now, that instrument imposes various obligations on us as residential landlords. The key ones include a requirement to carry out an annual gas safety inspection, a requirement to give a tenant a copy of a gas safety certificate within 28 days of any such inspection, a requirement to give the current certificate to a tenant prior to occupation of the property, a requirement to display the gas safety certificate in a prominent position in the premises. This is in circumstances where there are no relevant gas appliances in the room occupied by the tenant. The court hearing was on the 13th of September in 2018. Mrs. Rouncefield attended the hearing at the Trecarrell County Court to defend the case herself. The landlord was represented by counsel. Remember, Mrs. Rouncefield primary argument was that the Section 21 notice was invalid because the gas safety certificate had not been provided prior to the occupation of the premises. The landlord argued that because the gas safety certificate had in fact been provided prior to service of the Section 21 notice, the notice was therefore valid. Well, what did the judge say? Well, District Judge Rutherford took the view that because the boiler was not within Mrs. Rouncefield' actual apartment, there were no gas pipes, no gas appliances within her apartment. Therefore, the relevant provisions of the 1988 Act were not applicable. That was District Judge Rutherford's view. He held that there's no absolute time limit on the provision of the gas certification for the purposes of Section 21, and he therefore granted possession. Mrs. Rouncefield appealed this decision. The appeal was allowed because the gas safety certificate had neither been given to Miss Rouncefield in line with Regulation 36.6b, nor had it been displayed in a prominent position as per Regulation 36.7 of the same Act. So basically, the Act requires you, as I stated previously, to provide the gas safety certificate. But as you recall, this particular property is in a block of flats. There isn't any there aren't any gas appliances, no gas pipes, nothing gas related in this particular property. So the requirement in those circumstances is that you should at least display, in the absence of provision of that directly, you should at least display it in a prominent place somewhere in the building. So that's the 36.7 part of this. So anyway, continuing from where we left. So it was held that Regulation 36.6b and 36.7 both required compliance before the tenant begins to occupy. In part, the rationale for this was that a tenant moving into new premises needs to be sure that the gas supply in that particular property is safe and properly maintained, because obviously there's a potential danger here to life. The other arguments proffered would have been that a tenant would have needed to make an informed decision prior to getting into a tenancy. So yeah, that was that. So Mrs. Rouncefield then served a notice called a respondent's notice. She took on a new factual point. It was said that there had been a further gas safety check, and that check was carried out in February of 2018. And that no gas safety certificate had been provided in respect of that particular test. The failure to do so would then amount to a breach of a subscribed requirement so as to invalidate the Section 21 notice. The landlord contended otherwise. It stated that the certificate had been provided before the notice was served. The main conundrum for the Court of Appeal to consider was whether the landlord's initial failure to provide the certification prior to term commencement, obviously occupation, you know that now, meant that it was forever barred from serving a Section 21 notice. Now, this prompted a lot of discourse because whilst Regulation 2 of the ASTs expressly disapplies the 28-day period for compliance with the requirement for a landlord to provide a copy of the certificate to an existing tenant, no equivalent saving provision is made in relation to the requirement to provide the certification to a new tenant before they commence occupation. So in a situation where you've got a tenant, an ongoing tenant, you've got an obligation to provide the certificate every 12 months. And you fail to do that, maybe you provide it 16 months later or 20 months later, it's still absolutely fine under the regulations as currently drafted, as long as the certificate is provided before the Section 21 notice is served. So I think the real matter for discussion here was why would that not equally apply to a scenario where the relevant certification was not provided when the tenancy commenced? As such, the argument was there's such a disparity of outcome here, and that did not seem to fit with what the legislative framework would have required, or that would not have been the actual punitive intention of the relevant statutory instrument. So that was a subject matter for quite a lot of discourse and discussions at that particular Court of Appeal hearing. So just a quick recap of the relevant law. Section 21 Housing Act 1988 provides a really helpful no-fault notice only ground for possession, so you don't need to plead any fault doing on the tenant's part. However, there are preconditions to service of that Section 21 notice. I discussed these in more detail on the previous podcast that I've done, in particular the podcast on how to successfully and speedily evict a tenant. Anyway, a notice may not be given at a time when a landlord is in breach of a prescribed requirement. The prescribed requirements are listed in that provision, but for our purposes today, they include Regulation 36(6) of the gas safety regulations, which I have highlighted before. Remember those four requirements which I stated in relation to the provision of a gas safety certificate within 28 days of the inspection, provision of a gas safety certificate prior to occupation, the requirement to display it in a prominent position, and obviously to carry out an inspection. So those are the primary requirements. And as you remember as well, the summary of the facts is that the landlord had obtained a gas safety certificate prior to Mrs. Rouncefield occupancy of the property, and all the other matters. I don't think it would be right for me to go through those in any level of detail. So anyway, the Court of Appeal concluded that as long as the relevant certificate has been given before service of a Section 21 notice, the failure to provide a gas safety certificate prior to a tenant's occupation does not prevent a landlord from serving a Section 21 notice. The correct construction of Section 21A and the 2015 regulations was that the time period for compliance with both 36(6)A and 36(B) was disapplied. Appeal concluded that as long as the relevant certificate has been given before service of the Section 21 notice, the failure to provide the gas safety prior to the tenant's occupation does not prevent the landlord from serving a Section 21 notice. So that's such a welcome relief for landlords. It was therefore immaterial that the 2017 certificate had not been given to the tenant until November 2017. There was therefore no reason for the notice to have been invalid. The only issue was, as to the factual dispute about the 2018 certificate. Was it provided? Was it not? But that was sent back to the county court in Truro to deal with, because it wasn't a matter for the Court of Appeal to handle. So, in summary, that's about it. Failure to provide the original gas safety certificate prior to a tenant going into occupation is not fatal to service of a Section 21 notice, as long as it's provided before the Section 21 notice is served. Failure to carry out the annual inspection in time is not fatal, as long as it's given before the Section 21 notice is served. There are, however, some difficult questions which have been left open by the judgment. The first one being that, what is the position if the landlord has not, in fact, carried out a gas safety check at all prior to the tenant's occupation of the property? How will this be remedied? Is it possible to cure this defect? The second question as well was, what happens if a landlord fails to do the annual gas safety inspection so that there's actually no certificate to provide during the tenure of the tenancy? So, those are the two questions that I think that they still need to be tidied up. But for our purposes today, I hope you found this helpful, and do let me know if you've got any questions or any other topics that you'd want me to discuss, if you'd want me to do a webinar for you, for other fellow landlords, for letting agents, for whoever could actually benefit from getting a great understanding of landlords' obligations, a great understanding of various other matters that affect landlords. Please do let me know. Otherwise, until next time.
Thank you for joining us on Creative Legals. Remember, What you do not know could cost you. Stay up to date. Subscribe to our weekly updates using the links below. Remember, what you do not know could cost you. creativelegals.com. Faster, smarter, better.